engage legal firms to represent Essex Regional Retirement in the arbitration or possible arbitration issues with the former executive director.
Second on the motion? Any seconds?
No, Mr. Chairman, I think I made my point clear that I want to.
Sure.
We're in the hole. We have to dig ourselves out. We're not going to lawyer our way out of this hole.
I'll second the motion. Discussion?
I don't think it's going to hurt us to have a plan in place over the next couple of weeks to start the process, not to actually hire a firm, but at least reach out to draw some people in that we can look them over and interview them properly. So we're not, I know you don't want to spend a lot of money, but I don't think this would be money spent in this aspect of it, to review their resumes and look forward to, if we do plan to go to the arbitration, we're ahead by 2 to 4 weeks in time by doing this. It's not actually hiring someone, it's more the search for somebody.
Okay, certainly any recommendation has to come back to this board to be voted before we incur any legal bills. So this would be a no-cost beginning of a process that allows us, as Mr. Mertz identified, to run on a parallel track so that if for some reason, I appreciate the fiscal conservative part of you, and hopefully we'll be successful in that regard. If for some reason it doesn't work, we'll need to be in a position, although there's been no date specific identified when we need to respond to AAA, I'm sure opposing counsel will remind us of our need to do that if we're not successful in completing a dialogue or a negotiation with Mr. Bassett. So we need to be prepared for that, and I think if we then wait 2 to 4 weeks to do it, it's longer that we would in fact compensate Mr. Bassett. So the only thing I would say to the motion is that, and I think we'd have to take action on this motion, I may vote against this motion because I want to be specific that we would not use any firm previously hired by this board to get into a negotiation with Mr. Bassett, to get into the possible litigation with Mr. Bassett. I want to exclude any firm we've used previously. So we have a motion made. Second, any other discussion on that particular motion? Ms. O'Leary, you hearing us okay?
Yes, I'm hearing. I'm fine.
Okay. I have a tendency to speak at a very low tone.
I'm sorry.
There you go. That was perfect. The motion made and seconded. All those in favor? Opposed? Aye. So if we can discuss the possibility of an amended motion, I'd appreciate it.
Point of information, Mr. Chairman. If we take no action on this and try to negotiate it ourselves, at the end of the day in 2012, if we were to look at that contract and pay him until the contract was out without any additional legal expenses,
Right.
That's what I'm looking at, as opposed to trying to fight an uphill battle. That I look at the contract and it's pretty ironclad, and so.
Yes.
May I make a point? I
Sure.
don't think you're correct. I think
Okay.
the basis for the termination of Mr. Bassett was well-founded, based upon the findings of PIRAC. You have a very good position going into arbitration. That doesn't mean you'll win, but you had cause to terminate him, and the cause was reflected by the PIRAC report. That's defensible in that arbitration and gives you firepower, so to speak.
Yeah.
So don't feel like you have to pay him today for the contract. If you had fired him without cause, then you probably would have to do so. But you fired him with cause. That gives you reason not to pay him.
And to Mr. Monroe's comments, which I appreciate the efforts you're trying to make. Quite frankly, if the standard we're going to use in negotiating with opposing counsel is we're going to owe them to 2012, I don't want to even begin that motion. I don't want to begin that discussion.
Yep.
If the opinion is we're going to try to strike a compromise, then that's why I supported your motion, because you're trying to find a way in which this board is not going to incur costs in the discussion with Mr. Bassett. If the beginning of the
And
dialogue...
he wouldn't necessarily have to, he would have to incur costs himself to negotiate a settlement that would be less than paying him through 12.
I recognize that. I'm just taking a stance relative to the idea that the contract is ironclad and requiring this board to pay Mr. Bassett through the end of the contract. I agree with
I
counsel.
agree with you on that. I'm just saying that I would think that he would be willing to negotiate also, based on the fact that it would cost him a lot of money.
Yeah, hopefully that'll be the case. We'll find out. And there's also a standard that says sometimes you pay lawyers, and I'm not, with no disrespect to lawyers, I'd rather not pay them than pay them. Sometimes you pay them because it's a question of the public trust. And certainly any discussion we have relative to the termination of Mr. Bassett's contract and compensation will need to come with belt and suspenders relative to any action that any agency may take against Mr. Bassett. And I want that standard known as well. Let's go, if we can, back to the question of, the point is we're not going to incur a cost until we come back to this board. But in the absence of doing nothing, and I don't mean that as a criticism, taking no action and waiting 3 or 4 weeks to then start the action, it seems like we can do two things at once. Start the process you've identified, and at the same time prepare ourselves in case it's not successful. And at that point, if you decide you don't want to hire one of the firms that's been recommended, that's certainly your option to do. But I would encourage a motion where Mr. Mertz's motion as amended in some fashion.
I'd like to make the motion, my previous motion, with the amendment that we do not engage legal services of a legal team that has represented Essex Regional Retirement Board in the past.
I second the motion. Discussion? All those in favor?
Aye.
Aye. Opposed?
No.
No. Motion does not pass. At this point, we need to have some discussion about, is it the will of the board that we have no discussion about representation on the board? Representation relative to this matter to some point forward? Because at this point we have, or is it the expectation that Casey Lundgren will be handling this in terms of correspondence relative from opposing legal counsel and the like? Or the board themselves will handle it? What's the...
From my perspective, Mr.
Sure.
Chairman, that the board itself will handle it.
Any thoughts on that?
I think if we have legal counsel as been designated by Lundgren and Casey, I think we ought to use them for that particular thing. I don't think it's up to these two people to be writing up anything that has to be done with working with Tim's lawyer. I just don't think that...
It would be a subcommittee that would bring back a recommendation, so that's all.
Because we're also talking about general correspondence between opposing legal counsel and this board. We want to make sure that the opposing legal counsel understands who they're communicating with. We're saying that's solely going to fall on the board at this point. Thoughts about that?
I think I'd like it to go through our general counsel. I think it would be the appropriate manner, because I think it could help us identify certain issues. Again, I've never been a part of this process before, and I think I could use some guidance from our legal counsel. And it's just another person that's representing our board that could help us in this situation.
Any other discussion? Ms. O'Leary?
No, I'm all set, thank you.
So as I understand it, correspondence and communication from opposing counsel will be directed to general counsel of the board, but that the subcommittee in essence will handle the discussion and negotiation?
Right, that's what I was the understanding was happening.
I mean, part of what we're talking about, so we're clear on it, Bill, is that there'll be letter, there'll be correspondence, and we want to make sure that it gets where it needs to be and is responded to in a timely manner. Some of the things or actions that can be taken by opposing counsel are not specific to Mr. Bassett's right of negotiation or your decision or the board's decision to negotiate that contract to some conclusion. Other things can happen, other filings can happen. I'm not an attorney, so I can't speak to the specifics, but certainly certain actions could be taken, and I want to make sure that we understand as a board how we're going to process those. Are we going to process them to provide them to general counsel, or are we just going to report back those correspondence to the board? How do we want to proceed relative to that?
I would think we would need general counsel to at least look at the stuff.